This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Dr. Linsey Willis to the show. Now, Dr. Willis is president of L.J. Craig & Associates, Inc., a management and organizational consulting firm. She's a published author and a certified senior human resources professional. Dr. Willis holds a DPA from Nova Southeastern University. Dr. Willis, thank you so much for joining me here today on Engaging Experts.
Thank you. Hello.
Let's jump into it. So your background is in public administration and human resources, but how did you first become involved in expert witnessing?
Well, I was working on my doctorate, and somebody asked me if I was interested in doing an expert witness case because they knew somebody that needed somebody. And I said, well, I've never done one before. And I was an HR director at the time, and it was a pretty clear-cut case. And I was lucky it was on sexual harassment, and they settled the case for a little under $1 million based on my deposition. And I was like, are you kidding me? And so that's my first case in 1998. I fell into it.
So when you fell into it, were you given kind of a rundown on what to expect, what it was going to be like, what the sorts of questioning were going to be, or you just kind of hit the ground running a little bit?
I hit the ground running.
So if you could talk to your earlier self, what would you say to help quell some of the new expert witness jitters? What are the sorts of things that new expert witnesses should be advised of during their first couple of engagements?
They shouldn't take a case unless they feel that they have enough knowledge to be a good expert witness, and they should not just take it to make money. And to be an expert, you need to know to go to find the information, and you need to know what you don't know enough about. And so then if you need to refresh your memory, to verify that you know what you know, and then learn more about what you need to know more about with respect to that particular complaint and all the things that you've been hired to do.
Sure. Do you find that there is sometimes a little bit of difficulty understanding what exactly the scope is of your engagement and knowing what it is that you need to know?
No, because I'm good at knowing what I know and knowing what I don't know. And then I find out as much as I can by interviewing the attorney who calls me. So the attorney tells me what they're looking for, and then I ask questions, and I ask them to tell me as much about the case as they can. And, and then I decide whether I can help them or not. And then if I say, well, I think I can help you. And then we go back and forth, and then I ask more questions and even kind of strategize a little bit. And the majority of times I've talked to a lawyer on the phone, I've gotten the case.
Well, it's certainly the case that engagements are a two-way vetting process, right? Making sure that the attorney feels that you're the right person for the job, but also that this is as an attorney that you want to work with. So let's dig into that a little bit. Tell me a little bit about the questions that you're asked and the questions that you like to ask to make sure that you are the right person for the job.
Well, first of all, I started as a plaintiff's expert, and then over the past many years, I was asked to do defense cases, and I only take a defense case if I really think I can defend them. And a lot of times many of the lawyers are kind of like in a quandary, or they are almost in a desperate state because they know they don't have a good case. They know that the other side has more of a case just based upon reading and knowing things. So I just, I ask about if they have written policies and procedures. I ask them if they have any depositions taken. I ask them, where they are in the case. Are they in the beginning, the middle, or the end? I ask them, what documents do they have already? I tell them what more documents they should get if they don't have those. And so it's a back and forth conversation.
Absolutely. Let's talk a little bit about the initial contract. So when you are getting into an expert witness engagement, obviously there's a contract. What are the sorts of terms that you like to have in your engagement letters to make sure that you're protected in case of any number of eventualities. Do you like to take a retainer? Do you work on a project rate or perhaps an hourly rate? How do you structure your agreements?
I work on a retainer, and I say this is what for 16 hours, and then after that, I will either bill, 8-hour increments, and sometimes we modify it, and then I note what I'm going to charge for travel time, which I don't charge what most experts charge, and ask them to sign it, and never had a problem with anybody signing any contract, and indicating that they don't get their final report until I get paid.
Mm-hmm.
Because I've been stiffed a few times, by a few lawyers, where they don't want to pay you the rest of what your bill is for whatever reason. It hasn't happened that many times, because then you can just write it off, which is no fun. But you have to be really clear, and I make it very clear that I'm not going to chase down money. And I tell them up front, the report is required, and that's for federal cases. I have the report due on a certain date, and I'm not going to submit it until I have proof that the check's in the mail, or you've wired the money, or etc.
How should expert witnesses handle those kinds of eventualities? If you don't get paid, what do you do?
Well, not much you can do. You can just follow up with the law firm, and I haven't had to do that, fortunately, much, where it's just been not paying me, for mileage or whatever, quibbling on a few things. And then, one case, there's been a couple cases where the guy didn't have the money to pay me, and he ran out of the money, and, and those types of things. And then you just, kind of work it out with them. And then you've already sent the invoice. So because, I'm a business, an S Corp, I can write it off as it's billed, but it's not paid. So
Sure.
That's all you can do. But you have to be, really adamant about how you're going to work with the lawyers, because you're not going to, you're going to work with a retainer, and that's it, And sometimes I'll cut the retainer in half based upon what I know the case is about and how many documents they have. And I do that once in a while. But then I make it clear to them that, after the retainer is the half of the retainer's used up, I don't go continue the work until I get more money, because the lawyers do the same thing. They want to get paid, and they want a retainer.
Let's talk a little bit about preparation. So when you're going to go into a potentially contentious action, you're going into a deposition, you're going into a trial, bench trial, jury trial, how do you get ready? How do you like to prepare? And what are the things that attorneys should be doing that help you feel prepared for your big day?
Well, I've only been to court twice, but I'm waiting on a case right now where they were mediating it last week, and I haven't heard back, but I've done some prep already to go to court, because the lawyer's a board certified trial attorney, so he's takes most cases all the way. But I prepare by, I know my stuff. I read the report over and over, the report I've written over and over again. I summarize my notes. I have them all typed up, and I just read things out loud. Lately, I've this one particular case, I've recorded my excerpts of my report, kind of putting it into memory. You never know what the other side's gonna ask you. I've been in some really tough depositions from the other side, and some of them have just been pretty nasty.
Do you this could be a learning experience for newer expert witnesses? Are you able to elaborate on that at all, without obviously giving any names or anything like that? But what exactly it feels like to be impeached on the stand, and how you deal with that sort of pressure?
Well, no one's ever impeached me, but they had this lawyer in this deposition on the case that actually was a great case, because two defense law firms were taking this case. They were fighting. There was the plaintiff, but a defense law firm took the plaintiff's case, even though they mostly do defense cases. So you had two defense law firms, going back and forth, and I was their expert. And I was in that deposition for 7 hours. And in federal cases, you can't keep an expert more than 7 hours. Mm. And I had breaks, and I found out later that the lawyer that was deposing me was one of the partners, and they intentionally sent a partner because she would be more intimidating. And they actually had one of the HR manager in the room for intimidation purposes, but I didn't let it intimidate me. And I finally got to the point where I said, okay, this is the third time you've asked me that question. Same answer. Third time you've asked, because I know when they've asked me the same question more and more, and they're trying to lead you, and they do a lot of this hypotheticals, and I know how to deal with the hypothetical.
Absolutely. You've been doing this for a while. Has the role of the expert witness in general changed at all throughout your tenure as an expert witness? Have there been logistical changes, technology changes? Has anything struck you as being kind of new and fundamentally different as you've progressed?
What's one of the best things that for me is now you can get, well, before I wasn't doing it, but it's gotten better. You get the deposition online and you can actually highlight the deposition. You don't have to print paper. And the Dropbox and all the other ways they send the files makes it easier. And you can download something from the zip. And then I've learned that, no, don't print the paper. I only print paper that I need, pages I need to refer back to, so I don't have to go back through all the documents.
Absolutely.
So that's improved, having the ability to highlight in the PDF, your main points, and all you have to do is go back to those pages.
Do you find that virtual telepresence feels fundamentally different as an expert witness in terms of connecting to the finder of fact or answering questions or demeanor or anything like that?
Well, I've done several virtual depositions over the past several years, one during COVID, for example, and there have been at least two of them where I couldn't see the picture of the person who was asking me questions. And so that wasn't fair. And then one of the other ones I did, that they were blacked out. And I said, I'd like to see your face. You can see me, but I can't see you. So my lawyer said, on my side, you need to show your face. So the technology works really well. Like, when you have different people and the court reporter in there, I think it's pretty cool. And as a matter of fact, that case, I was in Georgia, I had suggested to the lawyers that why don't you have a Zoom meeting with me and pretend I'm in a deposition, and you just ask me a lot of questions, because they said I'd probably have to write a report, even though it was a state case and this was a personal injury case. And so many of the cases I've worked on are so egregious, unbelievable. So I said, why don't we just depose me, because then it will save you a lot of money and me time not having to write a report. And because I'm thinking more about, helping them settle the case. And so they deposed me, and I had a chronology ready. I had it all a spreadsheet with all the red flags and everything that took place with this employee. And they recorded it, and then they had a meeting with mediation with both sides, and they played the recorded meeting. And of course I wasn't there. They settled the case right there based upon the recorded deposition. And the lawyers were so thrilled, because they told me that they got more than they would have ever expected because of what I told them, suggested they do.
That's an interesting point, and I have heard from a lot of experts that cases are moving towards settlement a lot more often than they used to. Does that comport with your experience? But two, if so, does that change anything in terms of your work as an expert witness when things might move to settlement quickly? Does that, impact your ability to make a living off of being an expert?
Well, not really, because they're in all phases of the case, and the toughest ones are the ones that I get almost last minute. And because they wait till the last minute, because the lawyers don't want to pay the experts. They want to try to get around not having to hire experts. And only when they realize, I know I need an expert, and they'll contact you. This one case I had, that they contacted me less than a month before the report was due in federal court. And I told them, no, I know enough about the Fair Labor Standards Act to be dangerous. No, that's not my area of expertise. But then when they asked me if I knew about job analysis, and I said, I'm an expert on that. So the other expert they'd hired on the plaintiff side quit because he or she couldn't do the job. So I not only got the work done, I mean, I had made a lot of money. I was contracted out by one of the companies. When that happens, they have to pay like Round Table or other companies money on top of what the expert gets. So those lawyers were really, they didn't, the guy calls me up 3 hours before the report was due in federal court. And I said, well, I told you, you sent it to me last minute. I'm getting ready to send it, but I'm not releasing the report. And he said, but I have to have that report. And I said, well, I need to have my money. So they did a wire transfer to prove that they were going to pay me. But that case helped them settle it. But I really helped the situation.
Yeah, absolutely. Do you find that there's a significant number of engagements that are kind of last minute and you don't have as much time as you would like to develop your report?
The majority aren't, but I've actually done last minute engagements like within a month or a couple of weeks because they begged me and they tell me what they have. And I only do it if I know I can, even if I have to stay up in the middle of the night to do it, because they've said, please, I really need you. You got a great background. I do a lot of negligent hiring, negligent supervision, and negligent retention cases I'm hired by personal injury attorneys. So I know a ton about that, and I've helped with those cases as well. So I don't like doing them, but I'll do it if I feel I can squeeze in the time.
Besides, making sure that you have enough time to do the case, and obviously that is an important one, what else factors in? What's the calculus in deciding whether or not you're going to pick up a case, you're going to take an engagement? How often do you say no?
Quite a few times. I probably get, oh my God, I get probably 20 acquires a year, something like that. I don't keep track of, because I was hired for 3 cases in 1 week, but I get inquiries throughout the year. If you know what you know whether you can take the case or not. And then I'm very honest, and I tell them I could probably help you with this, but I can't help you with that. That's not my art. If you really want to hire me, I can only help you in this area. It shouldn't be all about the money. It should be about ethics and doing the right thing and providing a service and knowing damn well that you're going to do a really damn good job as an expert. I mean, I've got a really nice case list. I've done cases all over the United States. I've had repeat business from some law firms.
Yeah, that's an interesting point. So what's it like working across different venues? What sorts of preparation do you have to do when working in a new venue, be it a new state, a new level of government, or perhaps a federal case, international? How do you get ready for a completely new venue?
Well, I've worked on cases against multinationals. I've worked at the federal government. I had meetings with one federal judge, a meeting with another judge before it went to trial. Those are tough. But you have to know your stuff. As you go through, as you learn more, and you acquire more experience and knowledge, and then you just know so much of it's about the paper. How many documents do I need to review? And sometimes they do these document dumps. And they're basically dumping so much paper on the whatever side that it's kind of like looking for a needle in a haystack.
Do they sometimes inundate you with irrelevant paperwork? Should they do a better job, vetting which paperwork makes it to the expert? Because you're obviously going to charge for everything that you read.
Well, and if you're an ethical expert, and you don't like wasting time, going through paper that's irrelevant, I can go through stuff that I need to look at pretty quickly. But I asked them to tell me, which documents out of that whole file and Dropbox are the most important. And then, if I don't, all that stuff I don't need to review, I said, I don't want you to have me review stuff that really isn't relevant. I'm saving them time, money, and I'm not making the money, but I don't care. It's about why waste your time billing for stuff that's superfluous to your opinion. Doesn't make sense, because you can get burned out just reading stuff. So I know what documents I'm going to spend more time on and less time. If it's a policies and procedures manual, I know I'm just going to quickly peruse the table of contents and go to the policies and procedures that are relevant to my case, and then, and just ignore the rest. And I document how many hours, how long I've worked on it, because I don't want to overbill anybody. Here's what I read. This is how long I took. These are my billing hours and exactly what I read and how long it took, because then you're being ethical.
Right. I'd like to back up to something that you mentioned before, which was working as a plaintiff's expert versus working as a defendant's expert. What are the differences in the job itself for an expert witness when working for a plaintiff versus a defendant?
Well, you know that if you're on a defense case, the insurance company's going to pay you. And sometimes they're slow to even get you your retainer. And that got me messed up a couple months ago. I can tell you about when you're dealing with a big law firm, a national law firm with, several hundred lawyers. And, I don't think they're as customer service oriented to the expert as a smaller law firm or a law firm that you can interact with the paralegal and the lawyer. And this one law firm I work with, their nationwide law firm, and they never even got back with me. The lawyer was just didn't get me paid up front in time, and it was on my case about finishing. I said, but I haven't even gotten the retainer yet. So there's the ethics about the law firm too, and some of the lawyers are just in their law firm is just they're not well managed.
Yeah, and that's an interesting point because experts do often work on teams. There are paralegals, there's assistants, there might be a team of many lawyers instead of just one lawyer. There might be other expert witnesses that are working alongside you. How do some of those relationships work? How closely do you work with other members of the trial team that are not the engaging attorney?
It depends upon the case. I've worked with paralegals that have, kept on top of all the paper they've sent me, and I've had contact with them and not contact with a lawyer. I've had other cases where I've been in contact with both. Smaller law firms, I'm dealing directly with a lawyer. I have a more on hands-on with the lawyer, talk to the lawyer, and I always get all meetings scheduled. It varies based upon the law firm, part of the country, what the case is about. But my main goal and mission is to help settle cases.
Sure.
That's one of the things that I want to do is help them settle the case because, nobody wants to go to court, or the ones that go to court, I've learned a lot about that process, how, you have to decide if you want to put in front of a jury or not. But I write really great reports, and I would consider them bulletproof for the most part, because I have so much documentations and citations, and I do the research that, you're not going to be able to come back and say this woman, fabricated all this stuff. You need to have the factual evidence. You have your opinion, but you have to back your opinion up with all the factual evidence, all the citations. I do research. You have to, page numbers, you have to have all that.
What makes a great report besides, obviously it being accurate? Do you, for instance, like to use demonstratives? Do you make an index? What are the aspects of a great report?
Table of contents, mine are pretty standard. I always have the reference section. I have the opinions, and I may separate them out as, opinion 1, opinion 2, opinion 3. But I also have a literature review. I don't call it that, but a background about like the background checking process, for example, or a background on another issue so the reader knows that, okay, this is what the state of the art or is, or so to speak. And this is why here it is. And my opinion is that company fell below the standard of care, and, summarize each section. And it's pretty standard. But I've written a lot of reports, and I've done a lot of dissertations, and I've read a lot of term papers and what have you. So I know how to do all that stuff. I've done several rebuttal expert things. Oh my God. I've read some expert reports that were just horrible. Single space, no table of contents, no citations. It's just, awful. I don't know how they could even present something like that. Awful.
Let's move to a couple of general questions. What makes for a great expert attorney relationship during the course of an engagement? What are the important aspects of a good relationship?
I think an attorney has to show respect you as the expert, has to return calls or make sure somebody gets back with you. And there's many of them that don't. They don't even let you know what the case was settled. You have meetings on the phone, and you give an overview of the case. They ask you questions. You ask them questions. You're learning from one another. So that's a good kind of relationship.
Before we wrap up, do you have any last advice for expert witnesses or attorneys that are working with expert witnesses?
Know what you know and know what you don't know. and don't take cases where just for the money, and learn how to write good reports and chronologies. Do research to back up all your opinions. You can say, I know this, but wait a second. Here's what the literature says. Here's what the research says, journal articles and all that. And there you have it. It's all documented.
Sage advice. Dr. Willis, thank you so much for joining me here today.
Thank you so much, Noah. It was good to meet you, and have a great rest of your day.
And thank you, as always, to our listeners for joining us for another edition of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.